Hello and welcome to the Kenneth Verkammer Law Office Legal Podcast, the NJ Laws Tube. We are looking at recent Supreme Court Appellate Division cases that were discussed at the New Jersey Institute for Continuing Legal Education seminar handling drug, DWI, and serious motor vehicle cases from October 17th. And we're first going to look at what's called post-conviction relief matters, and that's where someone had an arrest and conviction, and in a second they seek to vacate their prior guilty plea. And the Court Rule 7:10-2 was amended to provide that the motions are to be filed within 5 years. Can the 5 years be waived? And the answer is yes in State versus Bringhurst, spelled Bringhurst. The court concluded that post-conviction relief PCR petitions brought pursuant to State versus Laurick must comply with the Rule 7:10-2 and are subject to the 5-year limits. However, those time limits may be relaxed to prevent an injustice. Because a Laurick PCR cannot be brought until there is a second or subsequent DWI conviction, the time bar should not mechanically be applied to deny the petition. However, to obtain the benefit of the relaxation of the time limit, a defendant must put forth a prima facie case for relief in his petition itself. And unfortunately for Bringhurst, say where the defendant's prior uncounseled conviction was 10 years earlier, he failed to put forth a prima facie case for relief. Therefore, the denial of the motion was appropriate. And that was State versus Bringhurst, 401 NJ Super 421 by the Appellate Division. See, let's say it's a conviction 30 years old. Let's say, what if there's no transcript? Well, let's say a judge could hear a PCR application in the court where the new charge was pending, and that was determined by the Appellate Division, State versus Bringhurst, spelled Binkiewiczz, an unpublished case, but used where, in this case, the defendant's first conviction for a DWI occurred more than 30 years earlier. His testimony and certification that he did not know he was entitled to counsel and was not asked if he wanted an adjournment to obtain counsel was sufficient under Laurick to establish that the conviction was uncounseled. Having found that the conviction was uncounseled, and since subsequent convictions exceeded the 10-year ban, the Appellate Division held the judge correctly applied the step-down provision and sentenced the defendant as a second offender with respect to incarceration, but as a third offender with respect to the DWI suspension. And that was State versus Bringhurst. We're next going to look at refusal to take the breath test. And let's see, back in 1987, the New Jersey Supreme Court in the Levitt case recognized confusion between Miranda and paragraph 36. Everyone's familiar with Miranda. Dragnet, TV shows, movies, you have right to remain silent. Everything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford one, one will be assigned. But then in DWI cases, the police need to read what's called paragraph 36. And paragraph 36 says you must take the test. You have no right to an attorney. You cannot speak to an attorney. Some people were confused. The Supreme Court in Levitt said, well, there could be a confusion. Well, let's say the person doesn't speak English at all. Wouldn't they be confused? Well, they would be confused, but that is not a defense. State versus Marquez. The refusal stands even if the driver does not understand English. The Appellate Division held the police have no constitutional obligation to translate into Spanish the standard statement under the breath test refusal statute, which is NJSA 39:4-50.2e, to a licensed New Jersey driver arrested for drunk driving who does not understand English. The Appellate Division reaffirmed the Law Division's holding in State v. Menendez from 1976 that no such translation is required. However, the Appellate Division recommends that the Motor Vehicle Commission consider having the statement translated to Spanish or perhaps other prevalent foreign languages. And that was State v. Marquez, 408 NJ Super 273, Appellate Division, 2009. Now it's been clear in New Jersey that the New Jersey drug statute permits a lab report if there's a no written objection by defense counsel. Let's say there's no written objection. Does a lab report come in upon notice? Well, interestingly, the United States Supreme Court held that the lab report is not admissible in a criminal case, and that was Menendez-Diaz versus Mas. The Supreme Court held the defendant's drug conviction is reversed where the trial court's admission of the prosecution's certificates of laboratory analysis stating that the material seized by police and connected to the defendant was cocaine of a certain quantity, that violated the defendant's Sixth Amendment right to confront witnesses against him. That was Menendez-Diaz versus Mas, 129, Supreme Court, 2527, 2009. And we next look at municipal ordinances. Let's see. And in particular, are noise ordinances preempted by state law? In the Appellate Division, State versus Krause said no. They said based upon the noise ordinance of the town was not preempted by a state statute, so an ordinance can be valid and conviction affirmed. That's State versus Krause, 399 NJ Super 579 Appellate Division. For additional information, contact the Law Office of Kenneth Verkaman, 732-572-0500. On the web at www.njlaws.com. That's njlaws.com. And benotguilty.com. That's benotguilty.com. At 2053 Woodbridge Avenue, Edison, New Jersey, 08817. Let's see, in our next edition of the NJ Laws Tube, we will look at additional cases decided by the Supreme Court and appellate courts. Thank you, and have a great day.